Can someone give me an indication you can hear us?
Thumbs up.
We'll take it.
All right, I call the meeting to order, and I will do roll.
Oh, I'm here now.
Representative Harris,
Present.
Crystal Mitzer. I believe I have indication she'll be out. Sandy Spiegel,
Present.
Richard.
Present.
Christopher Van Schleis,
Present.
Andre Green,
Present.
Deidre Shepherd,
Present.
Bradshaw Dickinson,
Present.
Senator Pitney.
Present.
We have a quorum. I believe we have all members except for.
All right, pretty good. All right, so first order of business is to review and approve the minutes. I know that they were on the table out front. If you're in the room, or sent out ahead of time as well.
Just one comment.
Yes, sir.
Okay, yeah, on the meetings, the minutes from last meeting, it said that I was present, so I wanted to make sure I know that I was not at the last meeting.
Yes, we'll make that correction. Thank you, Andre.
No problem.
Motion to approve the minutes.
Motion.
With Chris made the motion.
There's a motion. Is there a second?
Second.
All right. Any other concerns, questions, or edits? Hearing none, all in favor? Say aye.
Aye.
Any opposed? All right, thank you. We have minutes. Before we get to number 3, which is really the meat of our meeting today, and hopefully if you don't have it, you're pulling up the, for those of you online, the working document that DSHA staff has prepared for us. I wanted to just take a minute, and Bryce, maybe you can help me with this. We did receive last meeting, we talked a little bit about a FOIA complaint, and that was filed because of technical issues that we had at 2 meetings ago. We did receive a letter back from the Attorney General, and quite frankly, to me, it's a little confusing because on the one hand, I think that in their discussion, they acknowledged that we sort of did the best we could given the technology issues that we had. But then there was a concern about whether or not our response was made under oath or something like that. And so they found that we were in violation because our answer to them was not, I guess, properly filed. So I think that sort of resolves the issue. I don't think that there's another sort of conversation to have with DOJ. So I just wanted to make sure that we sort of tie that off. Is there anything else, Bryce, that I should say about that, or?
No, I think that's a great summary. And in addition, as the director explained at the last meeting, Dr. Rowe's comments are publicly available to anyone, and you can bring them up in the full court capture.
Good. Okay. Any other questions, or just wanted to tie that one up? All right. So what we have before us is a working document that goes through the questions that are put before us in the legislation. And last meeting we went through a number of those questions. I think we got about as we usually do, about as far as number 7 or so, and did not have a chance to wade further into questions 8 through 17. How would the committee like to proceed at this point?
Start at 8.
Should we start at 8?
I think that's.
Should we learn from our? See, is that what you're suggesting?
Yeah.
Okay. why don't we do that? Again, if we can get through this and have, a way of sort of expressing the committee's support for the answers as they're submitted here. I think that we can, still meet a March 1st deadline of submitting them to the General Assembly as a sort of a first report of this committee. With the understanding, I think as we talked last time, that does not finish our they moved into a second phase of it. But let's see how far we get, and if we don't get through it, and if we're not satisfied with the answers as they are put forth on this draft and as we discuss, then we'll go back and request some more time before we submit the initial answers to these questions. Does that sound good?
Sounds good.
Okay. So number 8 is a question about the predicted demand for loans or grants under this chapter. And this is an area, quite frankly, that we have not discussed in many of our prior meetings in great detail. Does anybody have any initial thoughts on the grants and loan portion? Maybe the department has administrative oversight of those funds. And you want to start with sort of telling us a little bit about how that program works and
Yeah, well, I think it might be prudent to start with how we would anticipate predicting the demand for loans and grants. So first, we need to understand the housing stock, which we haven't completely figured out, and multiply that by the anticipated amount of what it would cost to do the work that's being asked. So I know that Rich has done a lot of homework for us in providing the costs of what it takes to remediate a home that has lead in it. Of course, we're talking about lead safe and maybe not lead free, whereas a lot of the work that we're doing right now is lead free. We're also paying to relocate people, so our costs might look a little bit higher. I just feel like the formula would be an average cost times that anticipated housing stock. So we have a formula, but we don't have numbers to plug in there. So this is a fun algebra problem that I don't know if Rich has looked at or if you folks have any input on, but I can see the formula. I can't see the numbers. Right?
Yeah, can I ask a question first? I want to go back to the law, just so that we're clear. The department must establish and administer a lead-based paint hazard control grant loan program to assist small and large property owners with the financial costs complying with the requirement of this chapter, including any of the following: obtaining required certificate, remediation or abatement of lead hazards in a rental unit, paying for alternative housing for tenants when alternative housing is required, and it cites when that's required.
What section are you in, Secretary? Sorry.
It is page 7 of 13 of the final and gross bill, section 5408.
Perfect. Thank you, sir.
So I think my question, just so that we're clear about what we're talking about, is this your current program? Is this the program that you currently administer?
No.
Okay.
No, we actually don't have infrastructure in place to administer loans or grants, so this would be a heavy lift for us. What we do right now is administer contracts with the state funds that are provided through us through legislation. So we have no loan or grant programs in existence.
Looks like Representative Harris.
Yes, thank you. Number 1 looks like Representative Harris.
Hi, so I think all the things that were just said are important as far as like the formula and stuff. I could be incorrect, but I feel like the housing guys last time also said that they would do a basically like a survey of folks within property owner organizations in the state to see, depending on, are we looking for lead free or lead safe, if they felt that they would need the grant or loan assistance. So we would have some type of numbers from them as well to put into a report.
That might be a question. For you.
Sure. Well, I think this goes back to what we were talking about last time. We don't have really enough information to go on. Like, how do we know, how can we predict the demand when we don't know what the inspection is? Right. So if we had talked about last time with, the most feasible option was to do a visual inspection. So if we go in and we do a visual inspection of the properties and make sure that they're lead safe, we don't really need grant because that money can be done by contractors, by existing stock of contractors, RRP contractors, or depending on the extent of the work, just really any licensed contractor. But without like a clear definition of what a lead inspection is or a lead inspector is, I'm not sure we can come up with a demand for, for the grants and loans. And then, my feedback, so I reached out to, more than a handful. And I think the consensus is that, if this is going to be a program where we're going in and doing abatement work and making the house lead free, that's just not realistic. We already have numbers of $70,000, $80,000 average cost to make a house, and it's not even lead free. It's just lead safe at that point. Grants or no grants, that's not a realistic expectation for landlords to do. So I think the consensus of the folks that I spoke to and quite a few that reached out to me, if it gets to that extent, I think you'll see a lot of landlords deciding to, maybe exit the market. So,
well, I think last time we talked about, and I think it was a really good conversation around, lead safe being the first standard, and I think that's pretty clear in the law. As the requirement to be able to lease up. And I think we've had some good conversation on those other questions about, what lead safe means. I think there's still some question about the depth of the inspection to get to that designation, but
so I think as far as
I think though, before we even get to predicted demand, our comment on this question that may be that there currently isn't a
Grant or loan program.
lead-based paint hazard control grant and loan program administered by the department. I think that's an important point to make.
Yeah, it is. And, just to level set, there is one program within the Division of Public Health that administers loans and grants. It's called the Drinking Water State Revolving Fund. But again, that infrastructure is not housed in DHSS. The stewards of our fund are the Department of Natural Resources and Environmental Control. They have an environmental finance group. So they administer our grants and loans for us on our behalf. So we still, even though if anybody were to do research and try to see if we had any sort of infrastructure we could copy after, it doesn't exist in our department.
And so the existing program that you do administer for lead remediation is direct to homeowners, right?
Direct to contractors.
Direct to contractors, funding directly to contractors.
And then the homeowners, not necessarily to the tenants, we provide what they need to be rehomed, eat, drink, drive around.
Gotcha. Okay, Richard?
I just wanted to give you guys a number. So with my program, the Delaware State Lead-Based Paint Program, since there is no other program to get numbers from, I just wanted to give you a number of what we spent what our average cost for remediation was in the year of 2025 was $50,000.
Yes.
So to
So we went
Sandy's,
through, yeah, we
so
went
to
through some of
Sandy's
that data
point,
before. And quite frankly, I'm not sure that that's relevant. I think that what you do in your current program is very different than what is being asked to be done in this law in terms of bringing the unit to lead safe versus lead free standards, which I think is a significant difference when it comes to the cost of the work being done.
For sure.
And this is, this part of the code is particularly important because it is in fact sort of a, it's a way for a landlord to dispute the fees that are put in place, right? So they have that there are dramatic fees that are assessed on landlords if they're not able to provide that certificate before lease up. It's $100 a day per unit for small landlords. So if they leased for a year, that would be what, $36,000 or so, if I round.
Yeah.
Is that about right?
Yeah.
Yeah.
Give or take.
On the, per unit. And on the large landlord side, it starts at, I think it's 500, goes to 750 the second month and $1,000 per day per unit after that. So I'm not going to bother with the math. But a remedy to that fine would be that there is an economic prohibition for them to have done this work and provided a lead safe unit, and the availability of funds. That's why this question is important. Is one of those reasons why a landlord might be forgiven from those fines. Without a program, without funding in that program, I think that that complicates that whole sort of enforcement structure that's contemplated in the law.
Right, because they won't be assessed fees or there won't be enforcement if there is no fund available, right? Isn't that the contingency? Based on the availability of funds in a program?
The way I read it is that economic burden is there are a few reasons why those a landlord could dispute those fines. One, not enough inspectors. Two, not enough contractors licensed and authorized to do the work. And three, sort of an economic burden, and they apply to the department, and the department was not able to provide them with loans or grants in order to comply with the law. And so if there is not a program, then the only exemptions from those fines would be because there are not enough inspectors. And it says, the list has to be published. They have to try, to call 3 different ones, and then the department can grant essentially a get out of fine free card in some way to the landlord. I think it implies then that the unit can be leased without incurring that fine. But I'm in my rereading of it last night, while I was also trying to cook dinner for the kids, I'm not sure exactly what happens there, other than the fine being not charged. Yeah, forgiven.
So we don't have an answer for number 8.
I don't think we do.
Yeah, I think that's
it's
okay.
I think it and to your point about, so at the very top end, it's $50,000 per unit if we were to try to make them lead free and use the data from the programs.
I think
But we don't know still what it would be to make a unit lead safe. It could be encapsulation, making sure that paint isn't chipping and is painted over and is secure. So that might be a high enough level for the unit to pass a lead safe standard of a lead safe standard.
I just want to clarify one thing. I think on the last meeting, Richard had mentioned that his work, you know, that $50,000 wasn't to make it lead free, it was to make it lead safe. So I think that's a pretty.
Somewhere.
Want to clarify that?
Somewhere in the middle.
Yeah, we do both. We do lead free and lead safe because we use both methodologies when we're doing the work. But to make a unit, whether it's a rental unit, to make it lead free, it's going to cost more because you're removing every single component that has lead in it versus unit components that are not lead hazards. So basically, if you want to make it lead free, you're taking out all the components that have lead. So even the ones that are lead that are not hazards, you're also removing those as well. So obviously it's going to cost more to make a house lead free than lead safe.
One more sort of wrinkle here is back to your algebra. So if we're thinking of solving for X, the predicted amount of demand for loans and grants, it is a function of the number of units, which we don't know.
Right.
The economic burden of the landlords, which we don't know. And then there's also a breakdown of how much of the cost the landlord may be eligible for. So 100% for small, very small property owners, if I can call them that, 5 units or fewer. 50% for small owners who have 6 to 19 units, and 10% for large property owners. So it would be a prorated amount of each of those breakdowns, for which we don't know the numbers or the costs.
Agreed.
So again, yes, I think we can perhaps describe the formula, but I don't think we have any of the numbers to solve for.
On to number 9.
Okay, anybody else? Well, this is my favorite one. If not the department, that's you guys.
Yes, sir.
What state or local agency, department, or program is better suited to implement and enforce this chapter?
So I think this becomes difficult because the chapter includes so many things, right? There's the loan and grant program, there is the actual certification, maybe registration, and then there is enforcement, right? There's a lot in this chapter.
Mhm.
When it comes to who could be responsible for assessing lead-free or lead-safe, I think it's people that are already on the ground. So that's code enforcement. That's my opinion. And they already have responsibilities to make sure that homes are safe, right? Like they're already there. Just add lead paint as a hazard and let them assess as they do everything else for fire safety and et cetera. But I do understand that some of this points back to the landlord tenant code and their protections, right? And then I know that we have a role, creating regulations, maybe creating a loan and grant program, but there would be a lot of upfront building to do that. So I see where we fit in as the department. I just don't think overall with all the charges inside the chapter that it falls directly to DHSS, especially when it comes to creating the potential registry of housing stock. I think it's a very important piece. And actually, would help us answer many questions, right? Like even
It's
when.
not done through the law, the state law.
Oh, they took that out. I forgot. I keep going back to the original bill, sorry. But we need it to do the work. I mean, that's apparent. That's Sandy Spiegel's opinion, in case you can't see me on the camera, and I'll.
Way to own it, though. I like
Yeah,
that.
I will. I did it, I testified to it in Lake Hall, and I'll do it every time.
Director.
Yes.
Andre.
Yeah, yes, sir. Andre?
Yes, can you guys hear me?
Yes, sir.
Yeah,
I
I'm
just-
sorry,
I
your
just-
boxes are just very small, and so I appreciate Bryce keeping tabs on that for us.
Oh, thank you, thank you. I just had, I guess, a question or a comment in regards to where this responsibility would fall. I'm just curious, why would it necessarily fall under the landlord tenant code? Similarly to how landlords have responsibility to provide tenants with other documentation in regards to their rights for court, would this not also fall under that, in the sense that the landlord would have to provide to the tenant that they have done an inspection for the previous turnover, that this is a lead safe unit, not necessarily lead free, but more so lead safe. So the tenant is aware that something was done, and it has some type of a clean bill of health in regards to providing them that type of information. And at that point, if there was something that happened after that point, it would kind of fall back to code enforcement, because I'm assuming that it might be quite expensive to put this into a budget for another agency as well.
I appreciate that. I just wanted to clarify something, because again, part of my homework at the kitchen table last night was to look at the landlord tenant code, and lead doesn't actually appear there. So we've been talking about it as a landlord tenant code criteria. The word lead doesn't appear. I think what we're talking about is the EPA requirement.
Disclosure.
And so the EPA requirement is a disclosure of the presence of lead paint. And if any tests have been performed, the results of those tests or inspection reports, as well as a lead paint sort of awareness pamphlet, and federal dictated language in the lease agreement. Does that seem right? Landlords?
Well, yeah, you have a lead disclosure, right? And then, yeah, protect your family from lead pamphlet that you're required to give. That's under home guidelines.
And the disclosure is whether or not there is lead paint present.
The disclosure is whether you know if there's lead-based paint present, and if you do, then whether or not you provided documentation, that your documentation as per what lead exposures are there. So if there's
Not require testing, it does not require remediation or making the unit lead free or lead safe.
correct.
And it doesn't, so there's no requirement of anything other than sort of disclosure
Yeah.
to informing the tenants of what the landlord knows.
Right. I think the idea with mentioning the landlord tenant code was just kind of like, so the idea of housing this legislation with another agency that, to burden another agency with a large piece of legislation with, increased budgets. The idea with the landlord tenant code is we already have provisions in place to monitor landlords, to monitor tenants. So you, as a landlord, you're required to give certain documentation. You're required to keep the house in a certain condition. And if you don't, there's remedies. You have the right to counsel form that you're required to give. You have the lead disclosure you're supposed to give, landlord tenant code that you're supposed to give, the county code that you're supposed to give. And if you don't give all this documentation, there's remedies. So the idea is that this could be the same type of thing. So you have a lead safe or a lead free certificate. You provide that to the tenant. And then if you don't provide that to the tenant, then there's a remedy in place. And I feel like the landlord tenant code, you could easily amend that to say, hey, if you don't provide this documentation, here's the remedy in place for it. So we kind of already have the infrastructure for it. If it's a lead inspection, currently we're already doing visual inspections with Section 8. You've got that 1 hour course that's put on by HUD. We already have the course in place. We already have the inspectors in place. McBride and Associates, the third party administrator, They're already doing the inspections. So we kind of already have all the stuff there. It's about kind of tying it all together and making it so that it works with this legislation, which the reality of it is it will. It calls for a lead safe property. And if we go in and do a visual inspection, we can make it a lead safe property. And I think that's the idea where we came up with the landlord tenant code it could basically house there at the landlord tenant code. And we already have the remedies in place to administer it.
So in that case, you would just be adding one little section that says, provide this to your, because you said the lead disclosure is not in landlord tenant code because it sits at a federal level, right? At EPA. So all you would have to do for the landlord tenant code is just add your certificate of lead for your lead safe versus us having to build out an all new.
Correct.
Well, to be clear though, that's a very different thing. Notification to tenants is a very different thing than what this law is attempting to accomplish.
Right.
This law is, I think, attempting to accomplish that prior to lease up, at least once the sort of the ramp up gets done prior to lease up, a unit is inspected, A, and B, made lead safe.
So don't other parts of the landlord tenant code require that upkeep? Safety,
Correct.
et cetera. So
Yeah, so you already have the requirement in the landlord tenant code that the place be safe and clean and, it's habitable. And if those provisions aren't there, if that environment's not there, then there's remedies in the landlord tenant code where the tenant.
But let me ask you that. I mean, if a unit is not, if it passed it, let's say we have a unit inspected and it is not deemed to be lead safe, it isn't, there's nothing in the landlord tenant code that stops landlord from leasing.
Currently, that's not correct.
Okay.
So I want to make a comment in regards to that. It depends on the tenant, because a lot of my tenants are receive a subsidy, and the agencies themselves that are paying the rent for these tenants, they require a pre-inspection before the tenant can move into the unit. If there is any type of issue or violation that they deem needs to be remedied prior to move-in, that will stop the tenant from moving in. So if that's a part of the process where that visual inspection is done prior to a tenant moving in, then I think that would be an easier thing to incorporate into the process, because for any of my Section 8 tenants right now, they have to have a pre-inspection before they can officially sign their lease and move into the unit, which is not a part of the regular process now for all tenants across the board. But if you want to, adding that step in would be an easier process than a couple of the other remedies that we're talking about right now.
Yes, but also, just to clarify again, that is a requirement of those rental subsidy programs, not a requirement of the landlord tenant code.
Correct, yeah.
Yeah. Okay. So I think a comment could be made that there are alternative administrative environments that could be contemplated, that this bill creates a certain amount of potentially duplication between what the department, DHSS, would be asked to stand up in order to implement this law that may be already done by other entities, whether state or local, as well as other enforcement tools that would not that could go back to landlord tenant as a more natural sort of way to implement enforcement of the law. Again, I think that that's not a very specific answer, but I think maybe represents where we are in our thinking at this point.
Yeah.
Yeah.
Is there anything to add or change about that?
So are we suggesting to amend the tenant code, the landlord tenant code?
I don't, well, if the committee would like to make that recommendation, I don't personally feel like we're quite there. This is an area that we're going to need to continue to work on, like a lot of the other questions, but in order to give us, a report out, I think at least we've identified that there are potential alternatives.
Yeah, I think the only other recommendation that I did make when this bill was being considered was it would be just as easy as amending that code to make the building code requirements have lead-based paint as a hazard. And if that's the case, then when inspections are conducted, you have a hazard that needs to be remediated before a person can move in. And I mean, there's plenty of evidence to prove that lead-based paint is a hazard, much like you need everything else before you pass a building code inspection. So if it were incorporated there, that was a recommendation that I made previously as well.
But I think it kind of already is designated, so with RRP, if you're doing any contractor doing any work would fall under RRP guidelines.
Yeah.
So we kind of already have that language in there. So if if you're doing work, if a contractor's doing work and they're doing it in an unsafe way, and there's a lot of lead paint and lead dust and stuff like that, then that would already get flagged. So we kind of already have that kind of language in there to an extent.
Yeah.
The key, I think the problem that we're running into is that we don't have a good definition of what the inspection is or what an inspector is.
Yeah.
So a lot of these questions will answer themselves
If we had those.
if we can figure out, if we can agree on what a lead inspector and a lead inspection is. And we've kind of gone round and round on this topic. And we seem to, the most feasible option is a visual inspection that identifies chip paint, identifies dust. We already have inspectors that do it. It's already being done. There's already language, there's already programs, there's already tracking, it's all there. It's just whether or not we want to do that, right? And then it actually kind of takes care of the whole grant and loan program. So we don't need it. If we can go, we already have the inspectors, we go in, we do the inspections. It's going to be a reasonable ask for landlords to do that. And it's going to take care of the vast majority of lead hazards.
Yeah.
Right? Like we're not, the current programs aren't making the majority of houses lead safe. They're making them lead free. I mean, I'm sorry, they're not making them lead free. They're making them lead safe. Even if you go in and you do abatement work and you make a house lead safe, 2 weeks later, somebody can kick a hole in the wall and now it's not lead safe anymore.
And we've seen that. Yeah.
Right? I mean, that's the reality of it. So to go spend $80,000 to make a house lead safe and do all this abatement work, and then somebody can kick a hole in the wall, you're like, all right.
Drag the air conditioner in and out the window.
Yeah.
That's a good one.
So, I mean, but to that example, if you're dragging the air conditioner in and out of the window, if you're doing the visual inspections and tenants know about the visual inspections and they see chip paint, they call the landlord and say, hey, I've got some chip paint. Can you come take care of it? There's not a landlord in this state that wouldn't go, yes, I will be over.
Versus an alternative.
Correct.
Right.
You know what I mean? And if there are landlords that aren't doing that, then provisions in the bill that are going to penalize them, right? So, we need to, the whole idea of this is to come up with a reasonable plan, something that's feasible. And if we can, define a lead inspection and a lead inspector, most of these questions are going to answer themselves at that point.
And Chris, to your point, the part that you pointed out about RRP and those requirements, I think that identifies squarely where the responsibility falls for DHSS. We're here to make sure there is training and education, to make sure that people know how to remediate safely, build up that workforce, educate, train. I think that's our responsibility in this project.
And that type of stuff's already in place, right? And so instead of taking all these funds and creating this whole other department that's probably going to be a disaster, let's be honest, without spending tons and tons of money, that money can be used to help you guys to train additional RRP contractors and to educate contractors like, hey, you need to be RRP certified, right? And then to educate landlords like, hey, here's the visual inspection, here's the lead hazards. Like that's where the money should be spent because that's really going to help people. If landlords and tenants know the risks and they can identify them easily and they're reasonable to clean up and there's a reasonable workforce, then it's going to get done. And that's the whole idea is to protect people, and that's going to protect people. So something I noticed, I went to the bathroom and in the bathroom, this is an old building. I don't know when it was built, but I'm sure it was built a long time ago, prior to 1978. When you walk inside that bathroom, there is quite a bit of chip painting. And if you look in the upper left-hand corner by the mirror, there's water damage. And that's plaster. I know it's plaster because I can tell the way it's buckling. I'm pretty sure that that's lead. I'd really be willing to bet that. That's a lead hazard. How many people know that, right? Probably everybody in this room, but how many tenants know that and how many landlords know that? So if they know this is a lead hazard, you walk into that bathroom, a tenant walks into that bathroom and sees water damage. Hey, landlord, can you come fix this? And that's a reasonable ask. I want to know because if there's water damage, if I get it early, it's a reasonable repair. If the ceiling falls in, that's not a reasonable repair. Right? So I think this is something that we can make that would be effective and cost effective. And
Do you want to call the Secretary of State on the bathroom?
No.
Yeah, okay, good.
I might.
I was hoping I wouldn't have to.
Don't tell him I said that.
Char will be out here in a minute, don't worry. All right. Understood.
We have recommendations for 9, sort of. At least even the general statement you
I
made.
think a general statement about
The existing-
commenting on duplication on existing infrastructure that is not leveraged completely in this law and putting the department in a position where it is taking on responsibilities that it does not currently have. I don't recall, were there positions associated with this law?
There's no fiscal note associated until we get to the report and enactment.
Until the report and enact.
I don't think there's a fiscal note tied to this at all. There was funding provided to the DSLPP program, and I believe 350,000 of it is earmarked to create potentially the registry,
That's my understanding.
if that were to come to fruition. That's all I know about for fiscal, no positions. I don't know if Representative Harry Evelyn Harris, do you have any other input on positions or the fiscal note tied to this?
Sorry, I'm not the best with teams. Not currently. I think you all were pretty thorough.
Okay. We've made it through 2 questions, Secretary.
Run a roll.
I mean, 1, 2, 3, 4, 5, 6, 7 left to go. Hour and 6 minutes. And probably a couple of comments.
So the fiscal note, you're right, sort of hunts to the feasibility side of it. There is one. It was fiscal year 26 was not applicable, 27 was indeterminable, and it was indeterminable.
And they only do 2 years at a time, right?
Great, but the first one was 26.
So no, right, gotcha.
Okay. Number 10 was impact on property owners. And there was a note here that committee member
Me.
Chris was
So-
some information on it.
So I did reach out. I reached out to a lot of people. Reached out to a handful of realtors, a lot of landlords, and I've had a good amount of landlords call me and ask me what's going on with this piece of legislation, because obviously this is something that would have a big impact on their business, right? And as a business owner, you want to be able to plan. And if you can't plan and budget, that's a problem for a lot of reasons. So it was tough for people. So when landlords call me and say, "Hey, what's going on?" I'm kind of like, I don't know. We don't have a definition of a lead inspector. We don't have what the lead inspection entails. So it's kind of hard to say what the impact is. Depending on how the inspection works out, I've kind of thrown out a few scenarios when I talk to people. I'm like, it seems like, we're rallying around the idea of a visual inspection, and a visual inspection would be done by, kind of an existing protocol that HUD does for the Section 8 inspections. And there might be some additional pieces tied to that, but that's something that, I would say a good percentage of landlords are already familiar with, because if they're doing any kind of subsidized housing, they're already doing those inspections. And they already need to make sure the house is in, good condition and, a lead safe condition. So if that's the case, it's a minimal impact. If we take it to, some extreme where there's abatement work that needs to be done, that impact is going to be catastrophic. If you're talking $80,000 to make a house lead safe at best, and temporarily, let's be honest, that's not something landlords, you can't bear that cost. It's not like you're going in and doing $80,000 worth of renovations and putting a new kitchen, a new bathroom, new windows. Now your house is more valuable. You're doing $80,000 worth of abatement work that's kind of temporary at best, and there's no value to that, in the market. So, we all want to. I'm going to speak for myself and the landlords that I've spoken to, and there's quite a few of them that represent quite a few rental units in the state. We all want to provide safe housing, right? It's in our best interest, because if it's not safe, it's going to be a problem. I don't want problems, right? I want to provide a safe environment for people to live. I want to provide a affordable, right? Because if it's not affordable, I can charge whatever rent I want. But if they can't afford it, we got to evict them. So why do I want to put someone in there and that can't afford the place? We want the rents to be affordable. If they're affordable, the houses are safe. That's what we're looking for. So to answer this question, the potential impact, how do you really answer that question if we don't know what the inspection is, right? We don't have a definition yet. So if it's a reasonable, if it's a visual inspection, and we're doing a lead safe certification, and we're doing it at turnovers, that's something that's going to be a minimal impact on landlords, and it's going to be a minimal impact on tenants, right? If we take it to the extreme and we're trying to make the places lead free, it's going to be a disaster. And I would say, without exception, every landlord I've spoken to, they were like, well, if that happens, I'm going to start selling. And the reality of what happens is, when an investor, you have a house, a single family residence that you're currently renting, the ideal buyer to that single family residence is not another investor, it's a homeowner, which is fine, because you put people in, homeowners can buy houses. But what that does is takes affordable housing off the market. The multifamilies, they go to investors, but the single families, which are the bulk of the rentals, they're going to suffer. So if we can come up with a definition of a lead inspector and what a lead inspection is, kind of get some more guidance, I could definitely have some more concrete feedback from folks. I know there's a handful of, I think there's a handful of landlords that may be making some public comment. But I'd ask some people to show up, and I think we can get more folks to show up if I can give a better, better guidance on what we're actually doing. And the other feedback that I was getting is the frustration from landlords. Because you read this legislation and there's prohibitive fines. I mean, the fines are going to put people out of business. You get a $36,000 fine, you're selling your property. Let's be honest. And that's for a small landlord. So when you read this legislation as a landlord, you're going to panic. So I think people are frustrated. I know that landlords are frustrated because there is no guidance. We've been doing this for 5 months, and I don't have a good answer to say, hey, this is the path that we are moving forward on. It's kind of like, I don't know. As somebody look at me like, what do you mean you don't know? You've been doing it for 5 months. And I'm like, I don't know.
Just to clarify, you're saying that the potential impact could be minimal.
Could be minimal,
Could be minimal.
depending on the inspection.
Okay.
So if it's a reasonable inspection, if a lead safe inspection, visual inspection done by, an organization, I use McWright Associates because I know that they do the HUD inspections currently for Section 8, and they do a visual inspection. That's, I would guess $100 maybe. I don't know how much they would charge to do that. Then they come in and they do their inspection, and then RRP contractor can do the work. If there's lead, chip paint, any excessive dust, that type of thing, that would be a minimal impact.
So what minimal, so you're saying, what is the potential impact this chapter will have on small property owners? Minimal, if done with visual inspection.
If it's a reasonable inspection.
I just want to flag Andrea's hand up. And Franshawn did, but she put her hand down.
So, yeah, I appreciate that this is a complicated question, just like the formula with no numbers in it. It's similar, right? If a unit is lead safe, and the requirement is an inspection before lease up, if you have the inspectors to do that and you're not delayed, and that inspection is relatively cursory or visual, and therefore not expensive, that's the cost, right? The whole way through to much higher costs. And this question could be broader too in terms of uncertainty and all those other things. I will say that the implementation timeline on this, I respect that we've been doing this for 5 months and don't have final answers yet. But I think we have had a lot of good conversation that I hope will, and that's kind of the point of, to me, this deadline to submit a report with a lot of updates on our thinking and where we go, but we still have a lot of implementation ahead of us before we understand exactly what this looks like. Andre, I think, was number 1 there.
Can you hear me?
Yes.
Okay, yeah, just to kind of piggyback on what Chris was saying, I also went and had quite a few conversations with predominantly smaller property owners, smaller landlords. And it was an interesting response and conversation because many of them are aware of the proposed legislation, and a handful of them are Section 8 or subsidy type of landlords. So they already thought that there was something already in place because of the requirement for the visual inspection. When McWright does do not only McWright, because Newcastle County, they do some in-house inspections, but they already thought that the lead inspection was a state thing, not knowing that's just a part of what the agency does or McWright does. So they thought that this was already in place. The ones that were unaware of it, they had some concerns that if the cost became too prohibitive for them to keep their properties, they would just sell their properties, which is kind of what Chris was mentioning earlier, is that the unknown creates a broader fear than the known, because they don't know what that bill might look like in the future. And if anyone has been renting a property for any amount of time, dealing with any type of real, like, full on lead free matter becomes very, very expensive, to a point where there's no way to recoup the cost as a landlord, no matter what the rent is, because the market is the market. And for those who were not aware of the agency stuff, they felt like, well, if a tenant sees something or an inspector sees something, that should be the beginning of a process, versus you automatically have to send a company in every single time you have a unit turnover, or even a question from a potential from a tenant, which is what I was saying, because everyone's asking the question, well, what is the path that we're going on right now? And as we all know, we don't have a clear one just yet, but no one wants to have hazardous issues in their property, because that leads to many other issues. But the understanding for a lot of people was that, well, we already thought this was in place because a lead visual inspection was already a part of the inspection. So they were unclear that this wasn't a law already. And that's just because of how things are or have been done already with McWright and everyone else. But for those that don't have subsidy experience, it was a little bit more alarming for those people than others. I'll just put it that way. But short version is, everyone wants to provide safe housing. So however however it can be done, where it's done in a feasible manner, was pretty much the consensus that I got from the landlords, the small landlords that I did speak to, because one bill for $15,000 is enough to put a small landlord out of the business and remove that housing stock from the rental market. That's all.
Thank you. Is that Richard?
It is.
Yeah, I think it was Chris that was talking earlier. I just wanted to expand on what he said. So from my experience doing this work for a few years, when we have cases, basically, you're not going to have a house that is going to just need RRP work only or lead abatement work only. You're going to get, and I would say 99.9% of the time, you're going to get a mixture of both RRP works that's going to be needed and lead abatement work that's going to be needed. You're never really going to see anything where it's just RRP work. So that goes to lead safe, lead free. It's going to be a combination of both. So it's just something to keep in mind.
And that's because of the intent of the work. Yeah. Not because of,
Well, yeah, there was like one house that we did, and a lot of the work was RRP work, but unfortunately the dog chewed a hole through the door, and the door did have lead on it. So it was impossible for the RRP contractor to repair the door. It was a lot easier just pick the door off the hinges, wrap it in plastic, and throw it in a dumpster. So that would be considered lead abatement, because you're permanently removing a component, versus wet sanding, wet scraping, repainting, and all that, which falls under paint stabilization. So you're going to get a combination of both.
I wanted to expand on that real quick, because I had mentioned this before, and I think Richard had also talked about it. I think we've come to the conclusion that it's very difficult to make a house lead free. And I've used this, I believe I used this example before, but we did it years ago. We did a couple projects for the city of Wilmington. We were building net zero houses. So we got some grant money to do these net zero houses. And to do that, we did like super insulation and high efficiency systems. But the houses were basically falling down when we got them. They were brick row houses, and we gutted it. And when I say we got it, we took the floor joists out, roof, windows, window frames. I mean, it was a brick structure. We rebuilt it. Not only did we rebuild it, we encased it in closed cell spray foam. So essentially it was a brand new house. The city came in and did lead testing prior to selling the house. They found lead dust on the basement floor. I was like, how the heck did you find lead dust? There's nothing left. And, we kind of came to the conclusion that it was because the windows were open and it blew in from the neighbor's house. So the idea of lead free is a very difficult concept. The idea of lead safe is extremely reasonable. And the idea, if landlords are educated, if tenants are educated and understand the risks of lead and how to mitigate them, then it's very realistic, right? Do you see chip paint? Fix it. You see water damage? Fix the leak. You see a lot of dust? Clean it up. Use a HEPA vacuum. Years ago, HEPA vacuums were expensive. Now, pretty much every vacuum is a HEPA vacuum. You know what I mean? So it's very reasonable. So I just want to.
Franchon, do you have another comment?
Thank you. No, it seems like everybody's covering everything. I just wanted to reemphasize that, we have to make some adjustments in maybe the DPH regulation in that, and clearly identify lead inspectors and dust wipe technicians, because I don't think we have anything there. But that level should, if we have those kind of certifications, should meet the need of this legislation. So I just wanted to, but everything, I agree with what everyone else is saying.
Okay, thank you. Number 11 is about if resources are limited, what geographic areas or types of rental units should be prioritized under this chapter. Caitlin, you sent around to Elevate, I think it's part of the record of the committee, a document from.
Charles Kistler with the Help Initiative.
Yes.
So see, he had sent a public comment that was attached to the draft meeting minutes from the last meeting. It was like 60 pages worth of information total, but in that 60 pages.
Wait, should we quiz people to see if they read the?
So within those attachments that Mr. Kistler sent, he had sort of some suggestions for where to prioritize based on, what we know about the housing stock. Obviously Wilmington has a lot of older housing stock. I think Dover was one of the other areas that he called out.
So the committee has not reviewed that. You certainly get an A+ for reading the comments and highlighting ones that are most relevant to these questions like that. I breezed through it. I did not spend as much time on the report as I would like to, but for this question, I think that a comment about sort of urban centers, older housing stock is the best that we can do. And there was some that they used to get there that we could refer back to. But I don't know that this particular question is as important right now for us, because it also is building on incomplete answers to other questions. Maybe just a draft response, we could say that, we do have some information and would be prepared to make that kind of recommendation at some point in the future.
Maybe add a note that, households with children or children under the age of 6.
That was part of the data. Yeah.
Yeah, this data is actually our department's application to HUD. I think I was a contractor with the division. I now remember Mr. Kistler's name. He helped us write this grant application. So this would be a great resource for where to prioritize, obviously.
Although I will say that, the thing about having a free leasing inspection is that you don't know who's living there, right?
Oh, right.
Possibly.
Possibly, but.
So yeah, you can't target necessarily the population that will inhabit, but we can look at the blood lead levels of children that would have been in those areas previously.
So we think that there is a way to do this, although we haven't
And I mean, that's something that could be done with a notification to the tenant. So, fine, you moved in and there's no children under the age of 6. However, part of the notification to the tenant is if children move in under the age of 6, now call your landlord and get this lead safe inspection or something like that.
Also to include where children spend time. So that's part of the evaluation is like,
What'd you say?
not just where children live, it's where they spend time. So if you buy a home.
Around 8 o'clock. So if they go to bed before 8.
That's every single night, so, okay. No, that's true too. And there was some component about common areas and things like that. I think that report actually, as much as I absorbed, sort of, touching down on certain parts of it, I think it does provide a really good framework for that could be helpful. On 12, I mean, this is a marketing question. I think that it is important for landlords to be compliant with all regulations and law about leasing. My experience with landlords is that they're very good at understanding the laws and regulations that they are required to adhere to. When it comes to notifying them, any implementation of this contemplates at least a 12-month sort of ramp up from sort of we're ready to go to compliance being required. So I think again that is something that is something we can punt on because we're nowhere near there, but that we can say that obviously this is an important component of implementation.
So like education and outreach, but the best platform to do so, like, is there a nonprofit where?
Yeah, I mean, the Delaware Park Association would be a huge help. There would be, we could do some, some public outreach, some.
Greater Wilmington Housing Partnership.
There are several that I think would be helpful in disseminating the information as well as just, sort of DSHA department, DHSS and others sort of putting word out there. I think, local jurisdictions would be helpful as well. For those that have a registry, for example, we could do mailings and things like that.
And if it became part of the landlord tenant code, like if this was an additional addendum that you created with your lease packet, as the landlord tenant code is updated and you have to provide the, latest and greatest, that this could be part of the new update, basically. So landlords are already kind of getting notified with that.
Yeah, I think that we have enough experience setting up rules and regulations for landlords that we can draw on some of that. Procedures. This is a department implementation question that I think we can say that we are not prepared to answer because we don't know exactly what would be required. And same for 14, or actually, and 15. We are not yet at the point of being able to say what forms. We're not at that level of detail yet. So unless somebody has something more interesting to add than that, those 3 questions to me are a second, a much more detailed implementation question that we aren't prepared to answer yet.
I'm just going to make the same comment I made earlier. That if we have a definition of our lead inspector and a lead inspection, all these questions kind of answer themselves at that point. And
that's a
yeah. And if we do the, with a visual inspection, it kind of takes care of all this, and we already have the forms, we already have the training program, we already have the inspectors. So that would be a reasonable, feasible expectation.
I know for 13, I know you said we're not ready to touch that yet, but I would definitely recommend a registry. And as a procedure to be put in place to obtain a certification.
I think we kind of talked about the registries before as well. And one of the examples was New Jersey has a registry. And I'd have to get the exact number, but they spent tens of millions of dollars creating this program to register for for their lead inspections. And it's a disaster. you talk to like some of the lead inspectors over there, and the problem with the software is that you put in an address. Well, if you put it in once and you say, okay, this has the inspection, we can go back in and put that address in again, and then it doesn't recognize that that previous entry was made. So you'll have multiple entries for one property.
They need safeguards and
So when you go search, it's a mess, and they've been trying to fix it, and they've spent tons and tons of money.
So we know
To try
how to
and do
use
this.
Jersey.
Yeah.
Right.
But I guess the reason I'm saying that is because to create the software program and implement it, first you have to house it somewhere. So that's an additional budget line item. And then you've got to create it, and then you've got to manage it. So is it the bang for the buck really there? Or could that money be used for education and abatement work and training of contractors where it will actually do some good? And, kind of we don't have unlimited resources, unfortunately.
Yeah, I think it's, but I know you said we can revisit that.
Sure.
And the last question is a sub of 15, actually. It's a question about whether the courts require new requirements to enforce this law.
so here's,
And we haven't talked to the courts at all, so.
yeah. That last question made me go back to where this bill is actually implementing change, and I realized it's not the title where DHSS's powers lie. It is Title 25 and it's Chapter 54, and it actually, I mean, it does amend both, but the bulk of the chapter is amending the landlord-tenant code. So you had said you didn't find lead in the landlord-tenant code, but it will be.
Yes.
Okay.
Okay. Those last four questions proposed are again, I think just much more detailed than what we are prepared to answer. So we've gone through that, and I think we have at least discussed, read each of the questions.
Oh, there's one more question.
There's
17.
At least on our hand up. Sorry. There we
Come
go.
on.
That was a question you came up with. Well, I was going to say, it calls me out, so I probably should have just pretended.
Should legislative lead free certificate be filed with the Department of Health and Social Services?
And if so, wouldn't that create a registry? To be honest.
Kind of. They'd have to be. Right?
I don't know.
Isn't that implied in some other part of the, well, okay.
Well, I think that's one of the questions, is whether that's feasible. And I think, to what the previous questions we were talking about, you already have, on a federal standard, you have a lead disclosure you're supposed to supply to tenants. And that document's not registered with anyone. It's just a document that you're required to have. And if you don't have it, the fines, it's like $10,000 per missed initial or something insane. So, that's a program that's being administered, but it's not, you don't have a central registry to see who did it. It gets picked up. If you go to court and you don't have that document, it gets picked up there. You have the right to counsel. So tenants already get the opportunity to have free legal counsel, and the attorneys are going to pick up on it. And I mean, that document on any real estate transaction, the real estate transaction is not going to settle without that document. So, we already have procedures in place to make sure that, certain requirements are met. I don't know if we necessarily need to create a more burdensome program. We are kind of already have, right? You don't need to necessarily register it, but it'll get picked up on plenty of other areas.
Mm-hmm. Okay. There were some other questions having to do that we added to the 16 outline in the legislation. Questions about Philadelphia, New Jersey, Maryland, and some of the results of that work. To the question about inspector versus risk assessor and the level of inspection, there's also some notes there. I would not suggest that this committee has made a determination or recommendation on those, but I think that we have, some answers to questions that are leading towards at least some understanding of language. What we mean when we say risk inspection, risk assessor, risk inspector, lead inspector, things like that.
I was just gonna note that was information that Rich had sent with us.
Mhm.
Thank you, Rich.
Thanks, Rich.
So here's what, at 11:30 on February 25th, and both things are relevant. On the first, the law requires us to submit an initial report. We are also required to submit a report on January 1st of every year following that. And so that is, that's sort of that schedule. When you look at implementation of this law, the first date that it could be implemented would be 12 months after I make a certification that starting implementation or implementing the law can be done. It would be implemented 12 months after that. That date, if I were to do that between now and March 1st of 2028, 2 years from now. No, I'm sorry. If I were to do that before March 1st of 2027, a year from now, it would advance the implementation of the law. If that certification is not done before a year from Monday or whatever, Sunday, March 1st of 2027, then the law becomes effective on March 1st of 2020, barring any changes to the law. And this committee can make recommendations. I don't think that it can change the effective dates. I think that it can make recommendations to the General Assembly that those dates be changed. So here's what I propose our initial report to, and that'd be filed on or about, hopefully the General Assembly won't be too critical if we don't quite get it on the first. But that it would constitute essentially an update on the work that we've done. That it would have a cover letter from me that would state a couple of things, including that, as of today, we are not prepared to issue that certification, triggering a 12-month window towards implementation. That if the law were to be implemented today, it is not feasible. We don't have the policies, the regulations, the definitions, the staff, all of the things that would be needed to implement this law are not in place for its implementation. And therefore, we're not prepared today, of course, to say that it is feasible and trigger that 12-month certification process. That we have done a lot of work, that we have answered some questions, that we have answered, that we have partial answers to some questions. We have sort of guesstimates or approximations when it comes to number of units and things like that. And that we've also established that there are some of these questions that are probably unlikely to be answered with a great degree of specificity. I would also suggest then that the committee continue to do its work through January 1st of 2027, which is the next time that a report is due to the General Assembly. And then we attach to that letter the draft working document, just so that people know where we are with some of these questions, that we attach at least links and access to meeting minutes, as well as public input. My goal here is to basically give an update to those that we are required to update, which includes who do we send this to? I know it's the General Assembly. Oh, and the Director of and Librarian legislative services. Sorry, I guess that's.
They've added that to every.
So that it is filed. So we're informing essentially the General Assembly of sort of the update of where we are. And giving the indication that as of today, we don't have the environment and conditions to trigger the implementation of the law. How does that sound as a plan to, I think, meet the mark of submitting that report, but also being clear that there is, no clarity in terms of the answers or any specific recommendations or legislative changes that we're making at this point in time, or anything like that.
No
So-
comment.
So we're not prepared to enter a certification,
That's correct.
and that's what.
That's my assessment.
Okay. Do you believe if we ask for an extension that we could come to some type of recommendation to be able to enter a certification?
Filing this report, I don't believe would prohibit us from, as soon as March 2nd, deciding that we have everything in place that we need to implement the law. I mean, I don't think March 2nd is going to happen. I don't think we can certify to that on March 2nd, but I don't think that filing this update on March 1st prohibits us from filing that certification at any point in time.
So a recommendation and certification will be forthcoming. We're just filing our update at this point instead of requesting an extension, is my understanding.
I'm not sure what an extension does for us. I mean, to me, these reports are intended to provide updates to the General Assembly on what we've discussed and
Right.
what the public has said about this comment, this whole thing. To me, it's not a report that, it's a marker in time. I think it's important, but I don't think that it is. We're not prepared to make any specific recommendations, or I don't think, or we're certainly certified that it is a feasible thing to do at this moment.
I think what you said is accurate, right? Like we filed a report, but it's all clear that, we're not ready to make recommendations. Right? Like, so it gives us the opportunity to basically continue on.
I don't think that prohibits us from making recommendations or from promulgating regulations or doing anything else.
Before January, okay,
Yeah,
I'm just trying to make sure that I'm clear. If we don't ask for an extension to enter a certification, let's say 3 months from now, we come up with the recommendation to be able to enter the certification, we can do that. We don't have to wait to the following January.
no, I think that the reports that are required are, to me, just sort of, requiring us to make a statement at that moment in time. Red light, green light. And right now we're at red light, right? That doesn't mean that we can't turn the light green in June if the department promulgates regulations and we figured out all these other things and we're ready to go.
Okay, because my concern is that if we don't, our efforts to continue to work diligently to make sure that, we are prepared to enter a certification after we enter this initial report. I want to be able to keep up the momentum so we don't have to prolong, right, any more than we need to.
I think it's also just helpful to note, like, this committee will exist until we decide that no new deadlines for certification are needed, right? So until we say we have great deadlines and they're feasible and we're ready to go, like, we're gonna keep meeting.
Will the cadence change?
Yes.
Okay.
Yeah, well, so that's what we talk about next. Any other questions or concerns about filing the report as I've suggested, and is the committee okay with us drafting that cover letter from me as the chair, sort of summarizing that using this document, links to our minutes, links to public comments so that our report is giving people access to all of that sort of primary source documentation as well,
Yes,
I'm good with it. Yeah,
I'm good with it.
yes.
Any other concerns or questions? I think why don't we put that into a motion if you don't mind?
Make a motion to
Do that.
Do
move
that.
forward with, to do as secretary
To do what he
said,
did.
to move forward with that cover letter, and updates to the public and the General Assembly.
I second it.
Any other questions or comments? Hearing none, all in favor, please say aye.
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 Any opposed? Okay, motion carries. So. How does the committee want to, in a few minutes here, because I want to make sure that we have enough time for comments, so I'll give this, 5 minutes or so. How do we want to proceed with cadence, with the work of this committee?
I would say
Monthly?
recommend that we continue to meet monthly and maybe every 3 months, maybe twice, just to make sure we're being diligent and being able to prepare to enter certification.
Yeah, I think my first recommendation would be quarterly, but I also admit that sometimes after 3 months, I forget everything we talked about 3 months ago. So maybe 2 months is a better cadence. Not really sure.
So here's the other piece. I think these questions are important. And I think Representative Harris has suggested, that they were sort of a starting point. I think we might need to refine some of these questions and drop some of the ones that we are not as maybe concerned about. To me, the number of units, whether it's 40,000 or 60,000 or 80,000, it's a lot. I'm not sure that digging into that any further is a productive exercise. I think things like defining what, lead safe is and what inspection protocol verifies lead safeness is a very important thing for us to be talking about. So I think that that's maybe the next step for us here is to redefine some of the questions and zero them in. I mean, I think there are a couple of, I'd like for us to continue to think about this law as it's written. I think it's important for us to, when we're asked to determine feasibility, that's what we have. So some of that I think has to come from the department, which is designated for this. When it comes to especially definitions, I think that is within your wheelhouse of being the folks who know most about definition of lead free and lead safe.
Certainly.
So that's what I would suggest that we do, that we get a little bit more detailed about what questions need to be, what new questions we need to ask.
And so in that case, I think our first meeting, Representative Harris did note that we were required by law to answer the ones in this. We will have done that with our March 1, even if the answer is we don't have an answer. And now we can pivot and actually hone in on what needs to be done to make this actually happen.
I like the way you think.
Thanks, Chris.
Yeah, and so, I could see a process here over the next few months where, you know, if the department, for example, is charged with issuing a certificate, you know, what would that certificate look like? Not necessarily, you know, drafting and putting your skill at the bottom and the logo and all that. But what are the inputs that you would need to have? Would it be that the landlord submits the inspection report to you? You know, what other information would you need on that? Get to some of the details of what it would be, what it would look like to implement this.
I mean, I think to your point, that makes sense. And that probably the question that would be the most pressing would be what a lead inspector is and what the lead inspection entails.
Mhm.
And if we can answer those two questions, the rest are kind of a breeze.
Yep.
But that would be, you know, and again, if we go back to the visual inspection, you know, we already have all the stuff in place to make that occur. We already have the inspectors, the training program.
Mhm.
Landlords are already used to it, tenants are already used to it, inspectors are already used to it.
And if we have anything to link back to, right? So looking at the subsidized housing inspection protocol, you know, is that something that we can adopt? Now, it is the departments to adopt. And so that's kind of where I think we need that question answered from the department. If the department is tasked with adopting a definition of lead safe and lead free, you know, what questions do you have of this committee to do that?
Yeah.
If the department is tasked with certifying lead safe status for a unit prior to lease up, what does the department need of this committee in terms of the feedback to do that? What questions would you have? And if you don't have questions, and I think it's okay, well, let's look at what the department is suggesting.
Yeah, I can imagine that for us to be well informed, relying on the landlords would be important. So we'll have to look at what that might look like and create some questions. Just to get a holistic view. We can't pretend to understand the standpoint of, I mean, there's a reason this group body was created, so, yeah.
But I think rather than yeah, I think that the feasibility of this depends on whether or not this group thinks that it's feasible and, you know, what it determines. So it's hard to say that a piece of legislation is feasible without getting into that level of detail. And I think that's the next phase, is really looking at, in reality, not in legislation. No offense to the legislators on the call here, but in reality, what would implementation of this look like, and what questions would we really have to solve before we would get there? Let's try that.
Yeah.
I think that, you know, if we can start that, and so maybe the department over the next couple of weeks can look at some critical, look at the law, determine what it would mean for the department to implement it, and what questions would you have, would you need to have answered prior to its implementation?
I'd be happy to help where you need me to as well.
Thanks, Chris. We're on the case, Secretary.
Let's start there. And I think it's starting with the standards. You know, we've done a lot of prep work. I think your point, if we can write out, this is the definition of lead safe, and this is the standard for inspections, that does get us, if we can sort of get to final agreement on that, much farther down the road. That makes sense? Okay, can we move to public comment? Is that okay?
Absolutely. I believe we have 3 in-person public comment. We'll proceed with those and then do public comment. Members of the public will have 2 minutes to present their comments. Shared.
They should be able to hear you, but that microphone's right there.
So my name is Jeff Sheridan. I'm president of Housing Providers and vice president of the Department Association. I just want to share some concerns, I guess, from the landlord perspective here. So we've been involved with this piece of legislation, and I personally attended every committee meeting so far. I think as I sit here today, members come to me and ask questions. I can't tell them what a lead safe inspection looks like, who can do the lead safe inspection, how much it'll cost, if there's findings, what exactly has to be remediated, what sort of certificate they need. I feel like the legislature kind of threw us out of the airplane and asked us to go to country as we're falling, we're about to hit the ground. This is terrifying for landlords that want to invest money into properties that provide safe housing for tenants. There's no clear standard for us to follow. I'm not sure how they even guide landlords as to how to prepare for what's coming. I think having met for 5 meetings and not even having a definition of what lead safe is or who can do the inspection is a bit of a problem. So what I would encourage either this committee or the legislators that are on the committee to do is figure out exactly what you need to, so we can get a clear picture of what we need to do here. The questions that are being asked are impossible to answer until we define exactly what we want to do, and then we can talk about how to make it feasible. So I strongly encourage you guys to do that. We're happy to play a role in it. If you want to reach out to us, happy to provide guidance from a landlord perspective.
Thank you.
Next, public comment will be from Joe Brennan.
So my name is Joe Brennan. I'm the Government Affairs Director for the Delaware Association of Realtors. Again, in a similar fashion, we've been a part of this discussion with Representative Harris and main sponsor of the bill and the General Assembly from the inception of the bill. So, and we appreciate that process. It is been a conversation back and forth, and we've shed some light on a lot of the concerns already. We're happy to bring those concerns back up, but we feel some of them have overlay into this process. We started looking at this May of 2025. We sent correspondence and submitted public comments to the committee process for this. So we've been a part of it. We remain engaged even after the passage of the bill. We, by my presence here and part in this committee, want to continue to offer our resources. We have statewide resources that are available. We work with a ton of other stakeholders in this, so we're all on the same boat as trying to help get you the information. But again, in a similar fashion, we feel that there needs to be clear definitions of what we can start with a starting point so that we can get that to you. The definitions and providing clarity for that are another point to hit on. But we remain confident that with the continued back and forth, that we'll get to a point here pretty soon where we actually have some sort of direction on this. We appreciate the committee's efforts on this. Thank you, Director Peckles, and Caitlin for these committee meetings. We very much appreciate the opportunity to share. And if you need anything from us as far as resources, please feel free to reach out. I'll make sure you have my contact information.
Thank you. Our next in-person public comment is Ms. Renee Sproul.
Yes. Hello, members of the committee. My name is Renee Sproul. I am a small landlord, primarily with properties in the city of Wilmington. I'm actually also a licensed realtor. I work with a lot of investors, helping them buy, sell, and lease their properties. I've talked to a lot of them about this legislation. I kind of saw it coming down the pipe when it first started. I also have my own personal concerns about it for myself as to what I will do if implementation of this legislation becomes catastrophic. I agree with pretty much everything Chris Vanderslice said. We, of course, are concerned about the safety of our tenants. We don't want those problems, but at the same time, it has to be feasible for us to be able to implement it. And I fully support a lot of pretty much every recommendation that Mr. Vanderslice offered to the committee. I think you should strongly consider it. As I sit here and listen, I kind of wonder what's the hesitation, because he's kind of put forth some very specific ideas in terms of visual inspections, et cetera. So I'm wondering, no one ever really comments on makes a comment on what he has said, but I think he's put something out there that the committee could work with. And I would like to see the committee move forward. I think, to the lady's concern, that's probably the best way to go. Let's find an idea, start to move forward and flesh it out. So that way, at least we have something to take back to, hey, my clients, when they ask me these questions, as well as the rest of the landlord community, because ultimately we are going to be the ones at, taking the brunt of whatever comes down the pike and trying to help our tenants. And in turn, if we can't handle it, it's going to impact the tenants, and we're the ones providing the affordable housing that they need. Please do not alienate us in that process, because it's only going to hurt the tenants. Thank you.
Now can we move on to virtual public comment? It looks like we've had Amy Rowe. Let me enable your mic, Amy, and let's make sure that we can hear you. Amy, can you talk for us?
Okay, I think I'm able to unmute now. My name is Amy Rowe. Thank you for taking my public comment. I have a few things to say. I'm chair of the Childhood Lead Poisoning Prevention Advisory Committee. We submitted to the chair the 2023 Lead Safe Rental Housing Plan, which we developed as a result of SB 9. There were some really clear conflicts with our research, which was presented today. I'm not able to tell when someone's speaking in the room who's actually talking. So I don't know who said these things, but it would be helpful if people who were speaking could identify themselves for our benefit. One is that visual inspections through Section 8 are adequate. We found that to be wholly inadequate. Visual inspections for Section 8 programs do not assess for lead hazards. And visual inspections cannot detect the presence of lead. You cannot identify lead visually. If the Delaware State Housing Authority would provide to all of us the percentage of children or the number of children that live in Section 8 housing that did or did not have lead poisoning, then you could easily demonstrate that Section 8 inspections are inadequate for preventing lead. There should be, if that were the case, then there should be 0 cases of childhood lead poisoning in Section 8 homes. The proposal to have requirements based on age, we also identified in the Childhood Lead Poisoning Prevention Advisory Committee in our Lead Safe Rental Housing Plan, that is a clear anti-discrimination issue and that should be unacceptable by law. You should not have different standards for people based on age because of the experiences in other states. I am somewhat appalled that you want to meet less often now that you're submitting whatever this is that you're submitting. This is a urgent issue, and that people are proposing meeting quarterly, I think is very alarming. And I would encourage you to continue to meet monthly. And then finally, whatever this report is that is being sent to the General Assembly, the final language of that is not made available to the public to comment on. And I think that is also unacceptable. So before anything is submitted to the General Assembly, the final language of that should be made available to the public, and you should accept public comment on it. That concludes my comments.
Thank you. Our next public comment virtually, I believe, is Donald Farrell. Donald, you should be able to speak now. You have to unmute. You don't speak now, no. Yes. Be able to unmute now, Donald. Donald, can you hear us? on your mic is loud, you have to unmute yourself. I'm gonna try it one more time, on your mic. Your mic is allowed, but you have to unmute yourself.
Donald, if you have any comments, public comments to make, please unmute yourself, make them, otherwise submit them in writing. Let me clarify something from the interpretation from the Department of Justice. It is important for us to facilitate public participation by making these meetings hybrid. We are permitted through an electronic means of communication to allow the public to monitor the meeting and provide public comment if the public body is required to accept or provide an opportunity for public comment. We're not required to hold hybrid meetings. We do that to facilitate participation because we do want more input into this. If there are challenges with communications, if you are not getting from the hybrid nature of your participation in the meeting a satisfactory understanding of what's happening in the room, then I suggest that you appear in person. It also is very clear in their letter to us that technological problems that prevent or limit public access otherwise required under this chapter does not invalidate a virtual meeting or an action taken at a virtual meeting. That I'm reading to say that what matters is what happens in the room, first and foremost. So I think it's important for us to make sure that we're clear about that and that holding virtual meetings is an option. So if we're not providing the amount of transparency that we need to be, for your purposes, I certainly encourage you to be here in the room and participate with us in the room today, or any other meetings. So we will.
Now,
So his mic's available.
may I speak now?
Yes, Donald. Yes, thank you.
Yes, thank you. My name is Donald Farrell, and I live in Wilmington on the east side. I'm a landlord, tenant rights, and a childhood-led prevention advocate. I'm a small landlord, and I'm a member of the Greater Wilmington Housing Providers. I am an outlier among my landlord peers because of my advocacy. That being said, I've heard different figures being thrown around regarding the cost of making a unit lead safe versus lead free. Granted, the lead free option is more expensive. However, the lead safe option is more cost effective. Um, I heard one of your committee members say that it costs $80,000 to make a unit lead safe, but another member on your committee said, based on the jobs that he has done, he quoted a figure of $50,000 to make a unit lead free. Which is it? It seems as if there's an effort to inflate the cost of lead safe to make this entire effort moot. It would be helpful to see a breakdown of the cost involved. Granted, rehousing and the relocation costs are expensive, but what other costs are involved? Also, as a tenant rights advocate, I've heard from tenants in federally um, subsidized housing that the inspections are woefully lacking, and there are some tenants currently in litigation. Um, HUD visual inspections are not the be all and end all. With them, it's in or out. I hope that this work continues on a regular basis and is not constrained by a deadline. The children's health is at stake and continues to be at stake. Thank you so much.
Thank you, Mr. Donald.
That concludes public comment for this committee meeting. Just as a general reminder, public comment can be made in writing, online, or submitted to Caitlin.
Anything else from the committee members?
Motion to
We
adjourn.
will send out notice for the next meeting. Look for it to come out over the next couple of weeks. Shoot for probably let's call it mid-April, I think, is what we discussed. Somewhere a little, maybe more like a 6 to 7 week in between than the monthly that we've been on, but that should keep us moving.
Director, I believe we might have a public comment, but I could not see it on the other.
Okay.
Dr. Terry Hodge, your mic is enabled. Would you like to give public comment?
Yes, thank you very much. Can you hear me okay?
Yes, ma'am.
We can. Just one
right,
moment,
great.
so I can start the timer.
All right, thank you. Very quickly. My name is Dr. Terry Hodges. I am the co-chair of Action for Delaware's Children and a member of the Childhood Lead Poison Prevention Advisory Council. I've been listening the entire meeting. Thank you for the work that you've been doing. I would just like to respectfully encourage the committee to maintain your current cadence and if possible, and where possible, increase the frequency of the meetings, given the inability to complete the work to date, needing different definitions and additional information. Please continue the momentum as it's critical to avoid any further delays in the process. The communities impacted by these issues can't afford additional setbacks. It's also essential that we establish and maintain a comprehensive system or database of tracking identified rental properties where lead hazards have been detected without a centralized and transparent system to monitor these affected units, remediation status and compliance timelines. Our efforts will lack accountability and measurable progress. Additionally, I also just wanted to reiterate what Dr. Rowe had stated, which is that visual inspections for lead paint are not sufficient. Lead hazards are often not visible to the naked eye, and relying solely on a visual assessment undermines the intent of the legislation. The purpose of Senate Bill 9 was to identify and remediate lead hazards, not to create pathways that circumvent established health and safety protections. So if the processes that we have in place, and I did hear someone, and again, I'm sorry, I didn't know who made the comment, but I did hear someone say that, we have an infrastructure and we have processes in place and that they work, let's use those. But if in fact that were the case, the need for Senate Bill 9 and the work that your committee is doing, the work that the Childhood Prevention Advisory Council is doing, would it be necessary? This legislation exists because there's gaps that remain in protecting the vulnerable children and families from the dangers of lead exposure. It's our responsibility collectively to strengthen the oversight and ensure meaningful enforcement and not to do anything that will dilute the safeguards intended to protect the public health. So again, I do thank you for the work that you're doing and your continued attention to this critical effort. And that concludes my comment.
Thank you very much. Would anyone else like to give public comment? Seeing or hearing none. Director, I think we.
Or is there a motion to adjourn?
There was a motion to it. There's one more hand. Sorry. You see it?
That's not all I think.
Would he be DF?
That's not me.
That's Dr. Hodge. Oh, okay, good. All right. Motion to adjourn.
Second.
Franchise, I second.
Everyone, we'll be in touch with the next meeting dates.
That make this whole process, man. This is